Honorable Shri Om Birla ji, the Speaker of the Lok Sabha, my colleagues from the Supreme Court of India, my former sisters and brothers from the Supreme Court, Honorable Shri D.K. Upadhyay, the Chief Justice of Delhi High Court, the various former Chief Justices present here, the judges of Delhi High Court as well as the former judges from various High Courts, Dr. Abhishek Singhvi, the Member of Parliament and Senior Advocate, Shri Venkatramani, the Learned Attorney General for India, Shri Tushar Mehta, the Learned Solicitor General of India, the Members of Parliament present here in large number who also double as, many of whom also double as lawyers in the Supreme Court. Today we have a dialogue in the afternoon on that. I don't want to speak much on that. The Shri Vikas Singh, the President of the Supreme Court Bar Association, Shri Hariharan, the President of the Delhi High Court Bar Association, Their Excellencies, the Ambassadors and High Commissioners of the various countries, Shri Naveen Jindal, the Chancellor of the University, Professor C. Rajkumar, the Dynamic Vice Chancellor of the O.P. Jindal Global University, Ms. Shirin Moti, Shri Avishkar Singhvi, and the other members of the Singhvi family present here, various designated as well as non-designated senior advocates, the members of the bar, the students from the university, and the distinguished audience. At the outset, I would like to thank the organizers for giving me an opportunity to deliver today's lecture, the 11th Dr. L.M. Singhvi Memorial Lecture. It is particularly an honor for me to speak today, though I did not have an opportunity to meet Dr. L.M. Singhvi personally, but I knew him through his work and particularly through my father. My father shared the membership of Rajya Sabha almost during the same time when Dr. L.M. Singhvi and Mr. Falli Nariman, the scholars from the legal fraternity, were also the members of the Rajya Sabha. And my father had a close relationship with both of them since his son was associated with the legal profession. And they used to have discussions on the legal issues, and my father used to always tell me about the rich experience that he got through his discussions with both Dr. Singhvi and Mr. Falli Nariman. Their overlapping tenures allowed them to collaborate closely and exchange ideas, and learning about their work and camaraderie has given me a sense of personal connection to Dr. Singhvi's distinguished legacy. Professor Rajkumar has already spoken about the contributions of Dr. L.M. Singhvi, but in view of the breadth and depth of his work, I would like to take a moment to highlight a few more of his remarkable contributions. Born in Jodhpur, Rajasthan, Dr. L.M. Singhvi was a scholar statesman, a prolific author, an eminent jurist, a distinguished diplomat, and a prominent parliamentarian. In various roles, Dr. Singhvi made seminal contributions to law, governance, and public policy at both national as well as international levels. He was the second longest serving Indian High Commissioner to the UK after Mr. Krishna Menon, as Dr. Singhvi has already told us. He was the principal architect of Pravasi Bharatiya Divas, an initiative conceived to promote sustained engagement with the Indian diaspora and to strengthen cultural, social, and economic ties with non-resident Indians. Equally influential was his role as chair of the Committee of Panchayat Raj Institutions, where he recommended the constitutional recognition of local self-governance through Panchayat Raj. These recommendations laid the groundwork for eventual constitutional status conferred upon Panchayat Raj institutions, thereby deepening India's democratic framework at the grassroots level. Dr. Singhvi also was a distinguished member of the bar who mastered the advocacy, politics, diplomacy, and statesmanship equally well. Dr. Singhvi was elected as the president of the Supreme Court Bar Association on more than one occasion, and he was the founder president of the Supreme Court Bar Association Trust. I must also mention that at the time of his tenure as the High Commissioner of India in the UK in 1996, Dr. Singhvi graciously presented a sculpted statue of Mahatma Gandhi to the Supreme Court, which now stands prominently just in front of the staircase outside the Chief Justice's court. Over time, this statue has assumed a distinctive place within the architectural and symbolic landscape of the court, serving as a constant reminder and guiding emblem of truth, justice, and moral integrity. This memorial lecture is a tribute to him, and on behalf of all of us, I pay my tribute and homage to his distinguished career. It is equally important to recognize the efforts of Dr. Abhishek Singhvi in continuing and building upon his father's remarkable legacy. Through his sustained commitment to education and public service, Dr. Abhishek Singhvi has initiated programs that directly benefit students and society at large. One such notable initiative is the Singhvi Trinity Scholarship, established in memory of his late father. This scholarship provides financial support to a deserving Indian student to pursue an LLM at the University of Cambridge, offering not just world-class education, but also exposure to a truly international academic environment. By facilitating this opportunity, the scholarship embodies the vision of fostering excellence, broadening horizons, and nurturing future leaders who can contribute meaningfully to law, governance, and public life in India. Similarly, this lecture series stands as a testament to the enduring intellectual and moral legacy of Dr. L.M. Singhvi. By bringing together scholars, practitioners, and students, the series seeks to perpetuate his spirit of rigorous inquiry, public engagement, and commitment to the value of justice and constitutionalism. Each lecture serves not only as an academic exercise, but also as a platform to inspire critical thinking, dialogue, and reflection. I must also thank Dr. Singhvi for the good words he has spoken about me. I was not expecting them because every day he's at a receiving end in my court. And many a times I remind him about his visit to Nagpur in 2009 or 10. Because that time, nowadays the charter flights are very common, but a lawyer traveling all the way from Nagpur to Nagpur from Delhi, and the chartered flight was something, and as he said, Nagpur is a small city. And then not only that, we wanted to continue the matter on next day, but he had something urgent at Delhi. So he flew back, and then the next day again he came back after a day. He talked about my rise from a semi-science school to the place where I am today. It's all due to the Indian Constitution and Dr. Ambedkar's vision that I could hold this august office and get an opportunity to serve the nation and the society. He has also talked about I am not having a doctorate or PhD, though I was offered about 12 deletes by various institutions. I have refused them that I will not accept anything till 24th of November, 2025. The theme of today's lecture is humanity, dignity as the soul of the Constitution. Judicial Reflections in the 21st century. This theme invites us to engage with one of the most enduring principles of constitutional law, human dignity. In simple terms, dignity or human dignity refers to the intrinsic worth and respect owed to every human being simply by virtue of a human being. In the context of 21st century, this principle has acquired a new significance as courts across the world, and particularly in India, grapple with complex questions arising from technological change, social transformation, and evolving notions of equality and liberty. Today, my endeavor is to explore how the judiciary has interpreted the concept of human dignity in diverse contexts, from the protection of individual autonomy and privacy to the advancement of social justice and redressal of structural inequalities. By examining contemporary judicial reflections, we aim to understand how the commitment to human dignity continues to shape the values of constitutionalism and the contours of law, governance, and public life in modern India. But the discourse on human dignity in 21st century cannot be meaningfully undertaken without first understanding the foundational principles laid down in the decades preceding it. Human dignity was a central concern for the framers of the Constitution, deeply intertwined with their vision of a just and egalitarian society. As Dr. B.R. Ambedkar once stated that the social oppression of the so-called untouchables heaped upon them, and I quote, many indignities which are incompatible with the dignity and sanctity of human life, unquote. It is precisely these indignities of various kinds, that is social, economic, and political, that the Constitution was designed to remedy. As Dr. Ambedkar always used to say, that the Constitution is a weapon for bloodless social revolution. The text of the Constitution explicitly situates dignity alongside the core values of liberty, equality, fraternity, and justice. Signaling its centrality to the Indian constitutional project, the preamble enshrines this principle in clear terms and to provide amongst them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. As reflected in the preamble, this linkage between dignity and the values of fraternity, unity, and integrity of the nation is significant, as it underscores the idea that respect for each individual is not merely a personal or social value, but a foundational principle for the cohesion of society itself. When the dignity of every citizen is recognized and protected, it promotes a sense of belonging, mutual respect, and solidarity, which are essential for maintaining national unity and harmony. By anchoring dignity in these interrelated values, the Constitution envisioned a society where every individual, regardless of caste, class, or background, could live a life of respect. Furthermore, the phrase, assuring the dignity of the individual, is a direct commitment that every individual has inherent worth. It is particularly noteworthy that Dr. Ambedkar defined fraternity not merely as a social ideal, but as an intrinsic feature of democracy itself. He described fraternity as only another name for democracy, emphasizing that democracy is primarily a mode of associated living, of conjoint communicated experience, and that it requires essentially an attitude of respect and reverence toward fellow men. From this perspective, dignity or human dignity emerges as the core value of democracy, central to the very functioning of the democratic society. Although the term dignity does not find an explicit textual mention in Part 3 of the Constitution, which enumerates the fundamental rights, the judiciary has, through consistent interpretation, recognized it as a foundational principle underlying these rights. Reflections of human dignity are evident across multiple dimensions of the fundamental rights. The prohibition of arbitrariness under Article 14 ensures that state actions respect reason, fairness, and equality, thereby safeguarding the individual's sense of self-worth. Similarly, the rights against discrimination under Article 14 and 15 and the guarantee of equality of opportunity under Article 16 seek to affirm the inherent dignity of every person by preventing unequal treatment based on caste, religion, gender, or other personal attributes. Dignity also underlines the freedoms enshrined in Article 19, which protect individuals' autonomy in expressing themselves, associating, and moving freely, enabling them to lead meaningful lives. Most significantly, the right to life and personal liberty, as enshrined under Article 21, has been interpreted expansively by the Supreme Court to encompass the right to live with dignity, including personal autonomy, bodily integrity, and freedom from degrading treatment. Collectively, these constitutional provisions demonstrate that the protection and promotion of human dignity is a unifying principle underlying the entire framework of fundamental rights. I'll now refer to a series of judgments on various aspects of human dignity. The judicial recognition of the principle of human dignity in India began to crystallize in the late 1970s, largely in response to the widespread reports of inhuman and cruel treatment to the prisoners in the jails across the country. The courts observed that deprivation of liberty could not justify the infliction of humiliation, torture, or degrading treatment, and emphasized that even those in custody retain their fundamental human worth and rights. This period marked a significant shift in constitutional jurisprudence, where the judiciary began to interpret the right to life and personal liberty under Article 21 not merely as a procedural safeguard against arbitrary deprivation of freedom, but as a guarantee to live with dignity, respect, and human conditions, laying the groundwork for later expansive interpretations in areas such as prison reforms, rights of marginalized groups, and socio-economic entitlements. In Sunil Batra versus Delhi administration, a constitution bench of the Supreme Court took serious cognizance of the inhuman treatment of under trials, convicts, and individuals on death row. Justice Krishna Iyer emphasized that the human thread of jail jurisprudence demands that no prison authority is exempt from constitutional obligations, and that the forcible denial of fundamental rights constitutes an institutional outrage. The court condemned the use of iron fetters and held that practices such as solitary confinement and cellular segregation are both inhuman and irrational. In Sunil Batra 2 versus Delhi administration, the Supreme Court underscored that imprisonment does not strip an individual of their humanity. It famously observed that in the eyes of law, prisoners are persons and not animals, and affirmed that the judiciary has a duty to hold accountable and punish the divine guardians of the prison system where they go berserk and defile the dignity of the human inmate. Another judgment from 1980, Prem Shankar Shukla versus Delhi administration, centered around the constitutionality of handcuffing under trial prisoners. The court held that depriving a person of human dignity is not merely an act of causing physical discomfort, but an affront to their very humanity, striking at the core of Article 14, 19, and 21. The judgment emphasized that the guarantee of human dignity forms an integral part of our constitutional culture and is activated, and I quote, when we realize that to manacle man is more than to mortify him. It is to dehumanize him and therefore to violate his very personhood, too often using the mask of dangerousness and security, unquote. In Francis Corellin Moulin versus the Administrator, Union Territory of Delhi, the Supreme Court struck down a rule that restricted a detainee's right to consult a legal advisor of their choice, holding it unconstitutional under Article 14 and 21. The court emphasized that the right to live with dignity is an essential component of the right to life, and as such, a detainee is entitled to meet the family members, friends, and the legal advisors. These landmark judgments firmly establish that human dignity is a constitutional value that remains inviolable even within the confines of incarceration. Building on this foundation, the Supreme Court in the 21st century has continued to safeguard the rights of the prisoners, reinforcing their rights to human treatment and dignity are consistently applied even within the correctional institutions. The Supreme Court in Mehmood Naeem Azam versus the State of Chhattisgarh observed that a person in custody retains their basic human rights and inherent dignity, and the police officers are bound to refrain from inhuman treatment. In 2015, in Shabnam versus Union of India, the Supreme Court reaffirmed that human dignity must be preserved even in the case of a prisoner sentenced to death. The court held that from the confirmation of the death sentence by the highest court until its execution, the convict is entitled to be treated with full respect for human dignity, to the extent which is reasonable and permissible in law. The court explained the principle of human dignity in the following words, and I quote, "Human dignity is infringed if a person's life, physical or mental welfare is alarmed. It is in this sense torture, humiliation, forced labor, etc. all infringe on human dignity. It is in this context many rights of the accused derive from his dignity as a human being," unquote. The Supreme Court in the judgment of 2019 titled X versus State of Maharashtra, while holding that post-conviction severe mental illness will be a mitigating factor in committing his death sentence, emphasized that the right to dignity of an accused does not dry out with the judge's ink. Rather, it subsists well beyond the prison gates and operates until his last breath. More recently, in October 2024, referring to the principle of human dignity, the Supreme Court in the case of Sukanya Shanta versus Union of India struck down prison manuals which discriminate against individuals on the basis of their caste. The court held that such provisions perpetuate the idea that some individuals are inherently suited to the low status labor based solely on their birth, reinforcing deep-rooted caste inequalities. It was noticed that such provisions deprive prisoners from marginalized groups of a sense of dignity and the expectation that they should be treated equally. We also find that the principle of human dignity has played a crucial role in how the Supreme Court has derived unenumerated rights from the Constitution. Article 21, which guarantees the right to life and personal liberty, has been the primary foundation for recognizing such rights. As I stated, the court in Francis Corolle emphasized that the right to life is not confined to mere existence, but extends to living a life with dignity, thereby broadening the ambit. Another crucial judgment here is Mohini Jain versus the State of Karnataka, where the court declared the right to education as a fundamental right under Article 21. The court made it clear that education is not just a policy goal, but a constitutional necessity for a life of dignity. As the court observed, and I quote, "The dignity of a man is inviolable. It is the duty of the state to respect and protect the same. It is primarily the education which brings forth the dignity of a man. An individual cannot be assured of human dignity unless his personality is developed, and the only way to do that is to educate him." Education was highlighted as a facilitator for recognizing one's dignity. As we marched in the 21st century, the ambit and scope of human dignity was further expanded by the Supreme Court in M. Nagaraj versus Union of India, as the court held that it is the duty of the state not only to protect the human dignity, but to facilitate it by taking positive steps in that direction. In Sukanya Shanta in 2024, the court declared that Article 21 includes the right to overcome caste barriers as a part of the right to life of individuals from marginalized communities. This is to ensure that they can flourish in an environment of equality, respect, and dignity without being subjected to a caste-based discrimination which triples their personal growth. Another important aspect of the discourse on human dignity is that it is intrinsically connected to an individual's autonomy and especially to make decisions about their own life. It encompasses the freedom to exercise choice, personal agency, and self-determination. The courts have consistently recognized that human dignity and personal autonomy are mutually reinforcing. A person cannot truly live with dignity if they are denied the ability to make choices regarding their body, actions, or life circumstances. The interconnection has been central to judicial reasoning in areas such as reproductive rights, privacy, and the right to refuse medical treatment, where the courts have emphasized that respect for autonomy is a fundamental component of the right to live with dignity under Article 21. In Sujita Srivastava versus Chandigarh administration, the court observed that a woman's right to make reproductive choices is an essential facet of personal liberty under Article 21 of the Constitution. It emphasized that reproductive autonomy encompasses both the decisions to procreate and the choice to refrain from procreation, and that the fundamental considerations are the protection of a woman's privacy, dignity, and bodily integrity. The Supreme Court in Singhvi versus State of Karnataka recognized that a forcible intrusion into a personal mental processes is also an affront on human dignity and liberty, often with grave and long-standing consequences. A strong emphasis on dignity is made in the 9-judge bench decision in 2017 in K.S. Puttaswamy versus Union of India. This judgment declared the right to privacy as a fundamental right, flowing through various provisions of Part 3 of the Constitution. It was held, dignity cannot exist without privacy. Both reside within the inalienable values of life, liberty, and freedom which the Constitution has guaranteed. Privacy straddles across the spectrum of fundamental rights and protects for the individual a zone of choice and a self-determination. Privacy was held to be the constitutional core of human dignity. It affirms that living with dignity is essential to realizing the liberties and freedoms that form the cornerstone of our Constitution. In 2018, the Common Cause versus Union of India, the court permitted passive euthanasia in cases of terminally ill persons. The court reiterated that the term life in Article 21 encompasses the right to live with human dignity, which also includes the right to die with dignity. As an intrinsic aspect of the right to live with dignity, this interpretation underscores that the right to dignified existence extends throughout the natural course of life, encompassing not only the quality of living, but also the manner and procedure of death. Beyond personal autonomy, other dimensions of human dignity, such as self-expression and the right to make decisions, reinforce the principle that it is ultimately the patient's choice to accept or refuse the medical treatment. Across these judgments, the judiciary has repeatedly affirmed that protection of autonomy is a core mechanism through which the Constitution safeguards human dignity, reinforcing the interdependence of these two fundamental principles. I'll now turn to how the court has acknowledged human dignity not only as an individual right, but also as a collective or group value, particularly in the context of marginalized and socially disadvantaged communities. The judiciary has recognized that structural inequalities, historic injustices, and systematic discriminations can undermine the dignity of entire social groups, and that protecting their dignity requires affirmative measures, safeguards, and equality-oriented interventions. Through its jurisprudence, the court has consistently emphasized that dignity encompasses social recognition, respect, and the opportunity for marginalized communities to participate fully and equally in society, extending beyond mere legal protection to address entrenched social hierarchies and exclusion. In People's Union for Democratic Rights versus the Union of India, the court examined the violation of labor laws during the construction of the Asian Games complex in New Delhi and emphasized that whenever construction work is undertaken, whether departmentally or through contractors, the government or any public authority must ensure strict compliance with labor laws. Authorities should not wait for the complaints from workers, but must conduct regular and surprise inspections to detect any violations. The court highlighted that Article 23 prohibits forced labor in any form as it violates human dignity and fundamental human values. It further held that even if remuneration is paid, labor performed under compulsion or without free consent constitute forced labor under Article 23. The judgment underscored that labor must be provided voluntarily without coercion or compulsion as a fundamental aspect of respecting the inherent dignity of the worker. Importantly, this decision set a precedent for a series of subsequent judgments that reinforce the principle of the dignity of the labor, emphasizing that all workers, regardless of their social or economic status, are entitled to fair treatment and safe working conditions. Later highlighting the need to protect the marginalized communities, such as scheduled castes and scheduled tribes, in Chameli Singh versus State of UP, the court reiterated that the right to live as a human being is not ensured by meeting only the animal needs of the man, but it is secured only when he is assured of all the facilities to develop himself and is freed from restrictions which inhibit his growth. The court articulated that the true purpose of securing dignity of person and equality of status is to create supportive conditions which include the right to food, water, decent environment, education, medical care, and shelter. Such conditions will ensure that every citizen may grow and participate as an equal in our democracy. In a significant judgment in Visakhapatnam versus State of Rajasthan, the court laid down guidelines to prevent sexual harassment against women at the workplace. It was held that gender equality includes protection from sexual harassment and right to work with dignity, which is universally recognized basic human right. In Charu Khurana and others versus Union of India, the Supreme Court struck down the rules of Cine Costume Makeup Artists and Hairdressers Association that barred female makeup artists from becoming members. The court observed that equality cannot be realized without equal opportunities and noted that preventing a woman from entering a profession for which she is qualified not only denies her the opportunity to work, but also clips her capacity to earn her livelihood, which affects her individual dignity. The court remarked that all practices derogatory to the dignity of women are to be renounced. In Secretary, Ministry of Defense versus Babita Punia, a two-judge bench upheld the claims of women engaged in short service commissions in the army to seek parity with their male counterparts in obtaining permanent commissions. The court held to cast aspersion on their abilities on the ground of gender is an affront not only to their dignity as women, but to the dignity of the members of the Indian Army. Men and women who serve as equal citizens is a common mission. The court gave several directions to the Union government to grant permanent commission to women officers in the Army and consequential benefits. Subsequently, the women officers of the Army approached the Supreme Court in Lieutenant Colonel Nitisha versus Union of India to challenge the evaluation criteria applied by the Army to grant permanent commissions as unjust and arbitrary as the women officers who were in the age group of 40-50 years were being required to conform to the medical standards that a male officer would have to conform to at the age of 25 to 30 years. The court concluded that the process adopted by the Army to grant permanent commission to women officers failed to remedy the gender discrimination identified in Babita Punia. The evaluation procedure was found to constitute indirect and systematic discrimination, disproportionately affecting women. The court held that this discrimination inflicted both economic and psychological harm and constituted an affront to their dignity. The dignity of persons with disabilities has also been increasingly recognized by the courts as an essential facet of constitutional protection. Judicial pronouncements have emphasized that persons with disabilities are entitled to live with self-respect, dignity, autonomy and equality, and that society and the state have a duty to remove barriers, physical, social, and institutional, and hinder their full participation in public and private life. In CJI versus Union of India, the Supreme Court awarded compensation to the petitioner to be paid by an airline which had deported her from the aircraft because of her disability. The court found that this incident was discriminatory against persons with disability. It was noted that rights of persons with disability are founded on the sound principles of human dignity, which is a constitutional value and a constitutional goal. The court recognized the principle of reasonable accommodation for persons with disability. In Vikas Kumar versus the Public Service Commission, the court held that the provisions of scribe is mandated by law to ensure that persons with disabilities can live a life of equality and dignity with their bodily and mental integrity respected by society. It observed that it was fundamentally wrong for the UPSC to restrict these facilities solely to persons with benchmark disabilities. The court emphasized that all necessary support and accommodations must be provided to enable persons with disabilities to participate on equal footings. More recently, in Amarjain versus Union of India, the court was hearing a petition filed seeking directions to various respondents to formulate appropriate rules and regulations for conducting digital KYC, e-KYC, video KYC process through alternative methods to ensure an inclusive and accessible process to all persons with disabilities. The court held that, and I quote, bridging the digital divide is no longer merely a matter of policy discretion, but has become a constitutional imperative to secure a life of dignity, autonomy, and equal participation in public life. The right to digital access, therefore, emerges as an intrinsic component to the right to life with liberty, necessitating that the state proactively designs and implements including digital ecosystems that serve not only the privileged, but also the marginalized, those who have been historically excluded, unquote. Overall, the Supreme Court has been consistent in evolving the human dignity jurisprudence. To give examples, I normally do not refer to my judgments, but I'll take liberty to refer to my two judgments. The first regarding directions in the matter of demolition of structures, where the court laid down certain guidelines to prevent illegal demolition of structures, including the homes of the accused persons. In doing so, the court also noticed having a house or a roof over one's head gives satisfaction to any person. It gives a sense of dignity and a sense of belonging. More recently, in T.N. Godavaram Thirumpala versus Union of India, while dealing with the issue of hand-pulling rickshaws in a town in Maharashtra, the court held that the persons towing handcart rickshaws in Matheran do so not of their own choice, but since they have no other source of livelihood. Permitting such an inhuman practice, which hits the concept of human dignity in a country like India, which is marching towards becoming a developed country from a developing country, belittles the constitutional promise of social and economic justice. The court directed the state, as its duty under the directive principles of the state policy, to ensure that social and economic justice is done to the citizens, should form a scheme for rehabilitation of these handcart rickshaw pullers so that they are not deprived of their livelihood, at the same time prohibiting the human practice of handcart rickshaws. Significantly, the Supreme Court had earlier highlighted the connection between the human dignity and the directive principles of state policy in the Bandhuwa Mukti Morcha in 1984. Dealing with the issue of bonded labor, Justice P.N. Bhagwati, emphasizing that Article 21 guarantees the right to live with human dignity, free from exploitation, and the right draws its vitality from the directive principle of state policy, particularly Clause E and F of Article 39, as well as Article 41 and 42. He concluded that, at a minimum, human dignity entails safeguarding the health and strength of workers, ensuring protection for children against abuse, providing opportunities for growth under conditions of freedom and dignity, access to education, just and human working conditions, and maternity relief. I will not like to burden you with more judgments and would straight away come to my concluding remarks. I would say that the judiciary has emphasized human dignity as the soul of the Constitution. It has held human dignity to be a pervasive principle that underlines the very spirit and philosophy of the Constitution, shaping the core values articulated in the preamble: liberty, equality, fraternity, and justice. Across a wide array of judgments in the 20th and 21st century, the Supreme Court has consistently recognized that human dignity is both a substantive right and a normative lens through which all fundamental rights must be understood. It has been employed not only to safeguard a dignified existence for individual citizens, but also as a constitutional tool to expand, interpret, and harmonize rights, ensuring that the protection afforded by the Constitution is meaningful and comprehensive. In practice, this means that dignity serves as a guiding principle that connects rights, allowing the judiciary to develop a coherent and holistic framework for constitutional adjudication. Whether in the context of prisoners, workers, women, or persons with disabilities, human dignity transforms the understanding of autonomy, equality, and justice, ensuring that the law protects not only physical survival, but also the broader conditions necessary for a life of self-respect, freedom, and opportunity. By anchoring constitutional interpretation in dignity, the Supreme Court has ensured that the Constitution remains a living instrument capable of responding to evolving societal challenges while remaining faithful to the foundational values. I end my lecture by quoting from the privacy judgment, and I quote, to live with dignity. Dignity is the core which unites the fundamental rights, and because the fundamental rights seek to achieve for each individual the dignity of existence. I unquote. I thank the O.P. Jindal University and Dr. Singhvi for giving me an opportunity to address you on this occasion in memory of Dr. L.M. Singhvi. I once again pay my deep tribute to the enormous contribution of Dr. L.M. Singhvi. I am also thankful to all my brother colleagues and members of the bar who, in spite of tomorrow being a miscellaneous day, are present in large number. Thank you very much.
Thank you to the Chief Justice of India, Honorable Mr. Justice B.R. Gavai, for a stellar lecture. As a lifelong student of constitutional law, it was truly an educative experience to hear you speak about the foresightedness of the members of the Constitutional Assembly, the value of dignity in promoting democracy, the Supreme Court's evolving jurisprudence on dignity as a value, and the constitutional value at the interchange between dignity as a value as well as individual autonomy. On that note, I would now like to invite the Honorable Speaker of the Lok Sabha, Shri Om Birla, to kindly come forward to deliver the Chief Guest address for today. Welcome, sir.